Hello, good afternoon, everyone. Welcome to our MCO 3.0 webinar series entitled Property Development, Current Legal and Tax Issues, where our speakers today will be touching on key topical concerns that property developers face during this challenging period. I'm Ooi Bee Hong, the moderator for today's webinar. By way of a simple brief introduction, I'm a partner of RDS. I'm the head of the Corporate and Real Estate Department in RDS, KL office. I'm an alumnus of the National University of Singapore and have over 30 years of experience in a broad spectrum of corporate mergers and acquisition matters, corporate restructuring, corporate commercial matters, real estate, and other conveyancing related transactions as well. Before we get started, I would like to go over a few housekeeping rules. First, kindly turn off your video and mute your microphones while the speakers are presenting. Secondly, for the audience, you will have the opportunity to submit text questions to our speakers by typing your questions into the questions pane of the control panel. You will be able to send your questions at any time during the webinar or while the presentation is going on. And we will collate all these questions and address them at the end where we have a Q&A session. I would like to now introduce the three speakers for today, Mr. Chia Loong Thye, Ms. Tan Gek Im, and Mr. Saravana Kumar. The first speaker, Chia Loong Thye, is a partner of our Penang branch office. He is an alumnus of University of Warwick and a member of the Gray's Inn London since 1983. Admitted as an advocate and solicitor of the High Court of Malaya in 1985, Loong Thye holds a multitude of experience in various areas of practice, including industrial disputes, arbitration, and mediation. As a qualified mediator with the Malaysian Mediation Center since 2000, Chia Loong Thye has mediated on a number of commercial and civil disputes relating to construction, shareholders disputes, and also the administration of estates. Frequently engaged by the Malaysian Institute Latihan Kehakiman dan Perundangan as a mediation trainer, Loong Thye has shared his knowledge in mediation to the participants comprising of judges, legal officers, and practitioners from Malaysia and other countries. He is also a qualified adjudicator with the Asian International Arbitration Center, AIAC, since 2016 and has acted as counsel in adjudication hearings as well as an adjudicator. Now, in addition, Loong Thye has extensive experience in real estate transactions and conveyancing matters, acting for developers in land and real estate issues and also housing projects, and rendering legal advice to banks, developers, management corporations, and homeowners association. He is also actively involved in corporate and commercial matters, including joint ventures, trusts, and tax-related matters. Our second speaker, Ms. Tan Gek Im, was admitted as an advocate and solicitor of the High Court of Malaya in 2004. An alumnus of University of London, Tan Gek Im's area of practice include real estate transactions, corporate and commercial dealings, banking and finance, as well as wills and estate administrations. Now, Gek Im is actively involved in housing development projects, where she has rendered advice to developers, management committees, and also to purchasers, and has drafted various development agreements and documents for the management of housing projects. Gek Im is also vastly experienced in matters relating to banking and finance, having advised many banking institutions and financial institutions, including the drafting of documents pertaining to project finance, corporate banking, and bridging finance. In addition, Gek Im has acted for clients in reviewing and drafting of share sale agreements, consultancy services agreements, and joint venture agreements. Finally, Our last but not least speaker, Mrs. Saravana Kumar, is a partner and head of tax, sales and service tax and customs department at our KL office. Saravana has been recognized as one of the leading lawyers of Asia Law Profiles 2020 and has been named as one of the 40 leading lawyers under the age of 40 by the Asian Business Law's Top 40 in 2018. Now, with 80 over reported tax cases, he has appeared in benchmark litigations with sizable volume of wins in tax disputes. Recently, Saravana has also been named as one of the top 100 lawyers in Malaysia by Asia Business Law Journal 2021 and a leading individual for tax by Legal 500 Asia Pacific 2021. Saravana is also an adjunct professor with University Tenaga Nasional, which is UNITEN, and chairs the taxation section of Law Asia. Without further ado, I will hand over the floor to our first speaker, Mr. Chia Loong Thye. And thank you, everyone, and enjoy the rest of the afternoon. Mr. Chia.
Okay, thank you, Bee Hong, for that wonderful introduction of me. Hello, everybody. Good afternoon. I'm thankful for attending this webinar on this topic on property development. Today, I'm going to share with you some recent cases relating to housing development and the challenges faced by the developers. My topic is called the wax and wane of housing development. I'm just going to talk about the three cases, which we call mainly case, Albin Young case, and the Loh Tina case. So my aim is to share with you some of this recent development in the law, so that you all are updated and to be, in a way, be careful and to watch out for some of these legal impediment in your business. The first one I will talk about is this unmanly case, which I believe that a number of you have heard of this case before, especially those who are involved in housing development. Well, let me quickly just explain a little bit of the facts of this case, and maybe I would like to highlight some of the key legal issues arising from this. Well, this is a case where, like all other housing developments, this housing developer, BHL Construction, adopted the Schedule H SPA. And Schedule H is the prescribed SPA under the housing development regulations. And this happened in the year 2012. In the SPA, the time for completion and to deliver the vacant possession was agreed to be 36 months from the date of the SPA, which is normal. No? But later, the developer applied for an extension of time of 12 months to deliver the vacant possession. And the application was made to the controller of housing as provided for in the regulation 11.3 of the HDA regulations. And this happened in October 2014. Now, I need to explain a little bit and emphasize what is regulation 11.3. Here it says that where the controller is satisfied that owing to special circumstances or hardship or necessity complies with any of the provision in the contract sale is impractical or unnecessary, he may, by a certificate in writing, waive or modify such provisions. I'll just pause here to highlight the fact that the application to modify the provision, i.e. to apply for extension of time, is expressly covered under this 11.3. And it is the controller who make that decision. The other point I'd like to note is the proviso, which says here that no such waiver or modification shall be approved if such application is made after the expiry of the time stipulated for handing over VP. This suggests that the application to modify the SPA can be made even after the SMP has been signed, but so long that is not after the expiry of the time stipulated, that is not after the 36 months. So just bear that in mind. This is what Regulation 3 states, and this is what the developer is fully aware of. Next. But the controller, for his own reason, rejected the application. So again, under the HDA regulation, there is a provision which allows the developer to appeal to the minister, and that is provided for under Regulation 12. It says, notwithstanding anything to the contrary, any person aggrieved by the decision of controller may, within 14 days, appeal against such decision to the minister. So in this case, the Amingli case, the developer did that, and the appeal was purportedly allowed by the minister. So the extension of 12 months was given, and this was mentioned in the letter of 17 November 2015. But regrettably, the letter purportedly allowing the appeal was signed by one Jayasilan, and is said on behalf of the controller. It didn't say on behalf of the minister. This one, you ought to take note of this important piece of information, because it works against the developer in this case, and this was in fact noted by the courts. Next paragraph, next slide. Very briefly, what the High Court did was to say that the controller has no power to waive or modify the contract, which has the effect of extinguishing the rights of the purchaser to claim LAD, which is the liquidated asset damage. What it means is that under the original SPA, the time for completion is 36 months. And if the developer were to delay in completing the projects, or sometimes we use the word delay in handing over the vacant possession, the developer has to pay liquidated asset damages. So by extending it from 36 months to 48 months, the High Court says that it has the effect of taking away the rights of the purchaser to claim LAD. So the High Court said no, this is not allowed. Further, the High Court says that Regulation 11.3 is ultra vires the HDA, which is a social legislation intended to protect the interests of the purchaser. Now, this statement is very, very serious and damaging, in the sense that Regulation 11.3 was held to be ultra vires. Interestingly, when this matter went to the Court of Appeal, the Court of Appeal says that 11.3 is not ultra vires the Act. This is something which maybe we can discuss later, no? But unfortunately, for the developer, the Court of Appeal noted that the letter signed by the controller was the letter of appeal rather from the minister was signed by one Jayasilan for and on behalf of the controller, not on the minister. And on that point, the Court of Appeal says that the extension given was not valid. Next slide. So he went to the federal court, and the federal court also took deliberated on these issues, and they came to the conclusion that Regulation 11.3 of the HDA is ultra vires the HDA. But so as it stands today, the controller has no such power to grant the extension. But I'd like to examine a bit more on the rationale given by the federal court. Next slide. The federal court looked at section 24.2. 24.2 allows the minister to regulate and to prohibit the terms of condition of the SPA. But the federal court says that the minister is expected to apply his own mind to the matter and not delegate the responsibility to the controller. And the minister, in delegating the power to regulate to the controller by Regulation 11.3, may be construed as having exceeded what was intended by the Parliament. In other words, the federal court took on a very technical argument. Go back to the previous slide. Very interestingly, the federal court recognizes that the minister has some power under Section 24(2) of the Main Act to modify or to amend and to regulate the SPA, but he cannot delegate. So this is where the issue lies, because the federal court says that Regulation 11.3 is a form of delegation by the minister, and that is not allowed. So a very technical argument here, in my opinion. Next slide. And on that basis, of course, the federal court disagreed with the extension given to the developer. And at the same time, the federal court also took note of the letter, which I mentioned earlier, that it was signed by one Jasilan, not on behalf of the minister, but on behalf of the controller. Again, that is fatal to the developer's case. Next slide. And this is the same thing with the same point made by the federal court. Next slide. So in short, the federal court in Amelie case says that Regulation 11.3, which empowered the controller to modify the SPA, is ultra vires. Number two, it also says that the letter was not signed by the minister. Number three, which I thought need to highlight to the audience here, is that the federal court does recognize that if the decision to vary the sale and purchase agreement comes from the minister, as indicated in Section 24, then that may be a proper case. And interesting enough, we have a recent case of Albin Young, which was issue about the extension of time, which was given and signed by the minister. So in this Albin Young case, I will give you very briefly the facts of this case. A purchaser entered the SMP with the developer, where the VP is within 24 months from the date of SPA. And interestingly, the developer asked for further extension of time up to 59 months. The controller disagreed and only give up to 54 months. The developer appealed to the minister, who allowed the appeal, and the extension time is now back to 59 months. Next. Well, this matter went before the High Court. The High Court, of course, said that they're bound by the Amelie case and says that the extension of time given by the controller is not valid. But the High Court also went one step further to say that there is nothing in the housing development regulation that empowered the minister to give extension of time. Here, I would like to pause and like to stress on this point that the High Court judge may have gone one step too far. And the Court of Appeal, in this case, actually developed on this. Now, the Court of Appeal decision was made on the 29th of July. We have tried to get and search the legal journals and also the court, but we are unable to get a copy of the Court of Appeal. But there was one article written which says and talk about the Court of Appeal decision. And interestingly, the Court of Appeal says that unmanly case can be distinguished. It says that even though Regulation 11.3 may be ultra virus, it does not mean that the minister has no power. And under Section 24(2)(e) of the HDA is broad enough to interpret that the minister has discretionary powers to grant the extension of time. So here, I would like to say that there is a glimmer of hope to the developers who are faced with this unmanly dilemma, where if their case is a case where the extension of time was made by the minister, there is still a chance that they could able to succeed in any challenges by the purchaser. Next paragraph. So I will not mention this. You can get it in the. It's just a section 24. So in short, the unmanly case, although pose a very grave what they call dilemma and headache, I will use the word, to a lot of developers. But the Albin Young case seems to suggest that there's some hope. We do not know at this stage whether the Albin Young case has gone to the federal court. We hope that there'll be more discussion on this in the federal court on this issue of unmanly principles, and hopefully better what I call discussion can come up from that. Next, I would like to just deal on a different matter, which is again a recent case last year, and it's called the Low Tina case. This is interesting because it happens in a few places in Malaysia where developers and the landowners have gone into a joint venture arrangement, which is quite common, a joint venture agreement. But in this case, the landowner says that I will grant you a private lease. And the developers will take on this private lease and then they sell it to the purchaser. So what is sold to the purchaser is not a freehold land, which is the original status of the land, but instead a private lease. So the issue before the court, and this went on to the Court of Appeal, is whether the developer can transfer a private lease of a freehold subdivided title of a house to the purchaser. And here the developer initially applied to the controller for its consent to such a transfer of the lease, but that application was rejected by the controller. The developer proceeded to sign the prescribed Schedule G with some modification with the purchaser, transferring in effect a 99-year lease with an extension to a second period of 99-year lease. Okay, next. I would like to highlight some of the modification made in the Schedule G by this developer. Instead of the usual title, Sale of Purchase Agreement, you will see the modified version is called Build and Lease Agreement. Then they have what they call any reference to the purchaser agreeing to purchase the said land is being converted to the purchaser agreeing to the creation of a lease in the format attached. And lastly, any reference to memorandum of transfer has now been replaced with the word memorandum of lease. So in essence, next slide, is quite a total change in the way the S&P was structured. And the Court of Appeal says very strongly that this is no-go. It says where a developer makes changes to Schedule G that are not approved by the controller, the purchaser would have a right to enforce the SPA in Schedule G as prescribed as if unamended and unmodified. The statutory prohibition against modifying Schedule G contract sale and protection of the purchaser would be lost if the purchaser could not enforce what would have been the entitlement under Schedule G. A sale and transfer to them of the whole of the freehold title to the land upon which the housing development has been built. The court will read the SPA as having Schedule G drafted and incorporated into it so that no developer would have escaped. Next slide. So what happened is, lo and behold, the proprietor, the landowner, initially thought that the land would be a lease for 99 years and a further lease of 99 years. But eventually they will still get the land back. Suddenly found they have lost their freehold ownership. The judge says the proprietor was equally bound to transfer the whole of the subdivided title to the land to each of the purchaser. In this case, and being a party to the SPA, the purchaser have a cause of action against the proprietor, and more so when the proprietor remain the registered owner of the whole of the freehold. So this is very what we call damaging to the landowner. So my take, and I want to share this with you all, is that in those cases where you all want to enter into this kind of joint venture agreement between the landowner and the developer, please take note of this. You may think that you're only granting a lease and you get back the land after the end of the lease, but if you don't structure your sale purchase agreement properly, you find that you lose your freehold status. So in this case, the Court of Appeal, of course, the developer appealed to the federal court. I've been told by the lawyer acting for the purchaser here that the leave to the federal court by the developer has been rejected by the federal court. So this is the final decision on the Court of Appeal. Next. So these are the two points, two cases I'd like to share with you all. But just moving forward, that's one point only that to share with, and maybe even to the audience here, some of you who may be developers are involved in housing development, is what can be done about the Ang Meng Lee case. In short answer is very difficult because it's a federal court decision. It says that Rule Regulation 11.3 is ultra virus. So for long-term solution, one should consider a possibility of amendment to be made to the Act. That means asking the government to move a motion to pass a law in Parliament. And this law can have a retrospective effect. So there are cases where this has been done, actually quite simple. Just two examples here. In the Federal Constitution, it says that all provision of this clause shall be deemed to have been integral part of this article as of Merdeka Day. And then for copyright, it says that this act shall be deemed to have come into force on the 1st December 1987. So actually, a simple solution can be found, but it requires the full cooperation of the government. So that's my quick take on this, and I hope that you'll find it beneficial. Thank you very much.
Thank you very much, Loong Thye, for sharing the three very interesting cases of Ang Meng Lee, Albin Young, and also Lo Tina with us this afternoon.
Thank
Next,
you.
we would like to invite Tan Gek Im to speak on the recent development on short-term rentals in stratified developments. Over to you, Gek Im.
Thank you, Ms. Ooi. Good afternoon, everyone. Thank you for joining us today and to take the time to attend our webinar. Well, I'm sure all of us are currently stuck and miss going for a holiday or staycation. So I thought today I could share a recent federal court case that decide on Airbnb. Or in short, we call it short-term rental. So hopefully by discussing this case today, we can see the light in terms of the federal court decision, in terms of management allowing any short-term rental, especially in residential stratified properties. So as we all know, we have read news about complaints by homeowner, we have read articles, we have seen banners on apartments and condominium that we don't allow homestay. So even during this pandemic, when we are allowed to travel, there are still a lot of people booking on short-term stays in an apartment condominium, especially people with family. So there are a lot of concerns, especially when there are no proper guidelines, even during this pandemic, to control the influx of the guests coming in. I mean, on top of that, also, there's always a privacy issue where you have a lot of people, guests using all your condominium facilities, and also, some criminal activities as well. So we have seen that a lot of homeowners have actually lodged complaint, but no action has been taken. Well, the reason is because in Malaysia, there is actually no specific law that governs or legalize any short-term rental. So anyone can just, advertise their apartment for let in Airbnb, Travelgo, Booking.com, and yet, there are no particular law to govern in terms of the usage of, the premises on your apartment. So without the federal law, a lot of the states are actually taken the ham and actually come up with their own procedures that the apartment's owner have to comply with. Like in KL, you are required to register with DBKL. But in Sabah, I think the state government has actually prohibited Airbnb. That is actually to protect the hotel industry. Well, in Penang, there were talks about coming up with bylaws where if you want to run a Airbnb or short-term rental in the apartment, you need to get 75% residents that agree to that and pass a law. And in the event there is any infringement, there'll be fine and all that punishment for that. So that being said, there's nothing much really enforced in terms of governing the short-term rental in Malaysia. So if you look at stratified buildings, of course, we are governed under Strata Management Act 2013 and also the Strata Management Maintenance and Management Regulation 2015. And there's not a lot provided for in terms of very clear in terms of running a commercial activities in stratified buildings or especially residential buildings. So there are only two provisions in the Strata Management Act, Section 32(3) and Section 72, where it governs that a JMB, Joint Management Body, and also a management corporation may pass additional bylaws. So the additional bylaws are actually to regulate, control the management and the use and enjoyment of the building. We will go into more detail in terms of this section because it's quite relevant in the case of the federal court case of Inap Salil. So we will go into further discussion on that. So on top of the SMA, of course, we have the regulations that actually allows regulation to be passed or to control in terms of you cannot use the building that cause nuisance or dangers to others, or use the parcel against the plan that is approved by the authority. So it's quite closely related to the case because in that case, there were discussion about the use of the building and also the bylaws passed. So with that, let me maybe give you a brief introductory to the case. So this case, of course, is known as Inap Salil versus Mont Kiara Management Corporation. Okay, so the plaintiff in High Court is actually the management corporation, while the defendant is the person who owns the parcel unit and also runs the business of short rent. On top of that, there are also other defendants where he rented the premise from and also run the business there. So we will call them for easier discussion, the MCU as respondent and then the defendant as appellant for this discussion. So in short, the timeline of the case is in 2015, the Commissioner of Building in Kuala Lumpur actually came up with a circular where they are trying to curb the prevailing issue of using building for short-term rental due to all the complaints and whatnot. So arising from the appellant's use, of renting it out, it caused a lot of nuisance to the residents and a lot of incidents have happened actually in the common area of the apartment. So with that, the management actually then called a EGM and then enacted the house rule, we call it house rule number 3 here, to actually prohibit the resident units from being used as business use, so including short-term rental. And actually the residents agreed and passed with an overwhelming vote of 96 versus 4. So even though after in 2017, the House Rule 3 has been passed, the appellant in this case still continue running their business of short rental there. And also because of that, he was then fined 200 per day for failing to comply with House Rule number 3. Well, he wasn't very happy with it, so he actually went to the Strata Management Tribunal to say that the House Rule number 3 pass is actually invalid because it's in a violation of the Section 70(5) of the Strata Management Act, because it prohibits and restricts them from using their parcel, right? But in tribunal, the case was dismissed. So the MC, because the appellant still continued to breach the House Rule 3, the MC then went to the High Court to try to enforce this against the appellant. And in the High Court, the same thing. The appellant actually argued that the House Rule actually violates Section 75 of the Strata Management Act, which is actually impinging their right to deal or to use their building parcel. So if you actually look at Section 1775, it actually says that no additional bylaw shall be capable of operating to prohibit or restrict the transfer, lease, or charge of any dealing with any parcel. So that's why they are arguing that by passing Housing Rule number 3, you're actually restricting us from using our premise, which means to rent it out to lend it out as a short-term rental. And they also argue that, of course, the short-term rental is actually a tenancy exempted from registration. Therefore, it amounts to any dealing of the parcel. The MC, of course, replied and argued that the short-term rental is actually not a lease or not a tenancy, which is exempt from registration, and it is merely licensed to use. And as such, it should not be dealing as defined under Section 70(5) of the Strata Management Act. So with that, the High Court actually agrees with the MC's argument, the respondent's argument, and found that the relationship between the house guest and the defendant is like hotels. So that's why it's merely a licensee and a licensor, not a tenancy or a lease that is exempted from registration. And of course, because the SMA, like HDA, is actually a social legislation, so the MC are given power to make bylaws to govern the safety and security of the management of the apartment or condo or the strata pipe building. And as the interest of the strata body prevails over individual commercial interests. So the court actually looks into the interests of the parties. So therefore, they actually decide against the appellant, whereby the majority of the residents are using it as a resident rather than short-term business. So with that, the High Court actually dismissed the case, and aggrieved by the decision of the High Court, the appellant then went to appeal in Court of Appeal, but Court of Appeal also agreed with the High Court decision, wherein the High Court of Appeal actually held that in determining the nature of the occupancy, they must look at the nature of the use. So even though you're saying there's a tenancy, but actually it's a short-term rental, so that's not the actual use of the occupancy. And of course, they upheld the decision of the High Court, where the relationship between the appellant and the short-term rentals are actually merely a licensor and licensee. So with that, the Court of Appeal also dismissed the appellant's appeal, and then the appellant actually went ahead and get a leave to federal court. So in federal court, there were two questions posed. The first question is whether the house rules can override and supersede the land's express condition as imposed under Section 120 of the National Land Code. Or question 2 actually asks whether the enforcement of the House Rule number 3 was in violation of the Section 70(5) of the Strata Management Act. So the court actually looks into question why, because there's actually a conflict between the House Rules 3 and the express condition of the land use. So in this case, the verse suites actually is built on the land where the category of the land or use is building, and they are actually allowed to use for commercial for the purpose of service apartment also. So therefore, there's a conflict because the House Rule Pass actually says that you're not supposed to have run businesses there and short let, while the land actually allows commercial use. So briefly to explain, in Section 70, it actually allows the management corporation to pass the bylaws, while Section 120 National Land Code allows the state authority to impose condition and restriction on the land. So how would federal court actually resolve the conflict? Because one says that you cannot trump the use of the land, and the other says that the house rule can only regulate and prohibit things running in the apartment. So the federal court actually interpret the two provisions together, whereby they say that the state authority can actually impose condition on restriction on the use of the land, but it doesn't mean that the MC cannot pass rules or bylaws governing under Section 70 to control and to manage the use of the apartment. So this is actually in line with power granted under Section 225 of the National Land Code, where they say that when you exercise a law, you have to exercise it subject to other written law. So therefore, any rules imposed by the house rules by the management is actually not intended to revoke or alter any express condition of the land use. So therefore, question 1 is answered in affirmative, whereby you can have both the house rules being passed and also the restriction of the land. Okay, that's for question 1. Well, question 2, because the appellant argued that the short-term rental arrangement is actually a tenancy exempt for registration. So that's why it's recognized as dealing under the Section 206(3) of the National Land Code. And that exclusive possession actually creates a tenancy. So the court has to look into whether this short-term rental actually is a tenancy or just a mere license. If it's just a mere license, of course, it doesn't fall under Section 70(5). And to decide on that, the court actually looks into a lot of case laws, including foreign authorities, to explain the difference between the law on contractual license and tenancy. So basically, the court tends to look at have questions like, does the short-term rental have exclusive possession, and what are the intention of the parties? So to prove that whether there's a tenancy or just merely a license. So the court doesn't think that it's necessary to say any test is preferred, but they will look into the particular facts and circumstances of the matter to decide whether it's actually a tenancy or actually mere license to use the premise. So in the federal court actually, well, looking at all the cases, decide that the operation run by Inap Salil in the apartment is actually similar to Airbnb, whereby the host has a right to re-enter the premise and remove the occupant anytime at the expiry of the period where they're supposed to stay there. Well, for tenancy, actually, if the tenant refuses to vacate, you cannot just remove the tenant. You need a court order to remove the tenant from your premise. And similarly, also is like Airbnb, where the tenant of that place do not have exclusive possession of the premise, like a actual tenancy tenant that will have. So with that, the federal court actually says that the arrangement Inap Salil has is just a mere license and it doesn't amount to a dealing. Therefore, Section 17(5), where the rules were passed on, is not ultra virus. So the answer to question 2 is negative. That means that the short-term rental is just a license and not a tenancy. So again, the appeal was dismissed, and the federal court agrees with the decision of the High Court and Court of Appeal. So from this case, we can see that management can actually pass bylaws to prohibit short-term rentals, because even though the land actually allows commercial use. So moving onwards, the question asked now is, does all short rental is prohibited? Our view is, of course, not. Of course, if the building plan and land use is for commercial purposes, you can still run commercial activities on the land. And of course, provided there's no bylaw passed to disallow any short-term rental businesses at that premise. But that being said, because at the beginning of my talk is that there's actually no law or regulation to govern and regulate short-term rental. So that's something that we need to keep pace with all the changes, because as we know, Airbnb, Tribunal, Booking.com are all very popular throughout the world. So Malaysia will definitely have to look into it. So at least there are proper regulation and guidelines to prevent residential properties from being misused, or the residents going against the bylaws of the passed by the apartments. On top of that, of course, if you look at Strata Management Act, there's actually not sufficient to govern commercial buildings. More so, you can see the provision provided for are mostly to regulate for residential. So we need to improve on the Strata Management Act. And of course, similarly for the HDA, looking at how most of the apartments or the development nowadays are usually mixed development, where you have a commercial component and also the residential component. So we may have to look into to improvise the HDA to cater to current needs and current use. But of course, the challenge here is, of course, to balance between the rights of the, the commercial needs and also the individual parties here. So with that, I will end my talk for today. So I pass this back to Ms. Ooi.
Thank you, Gaim, for that very informative and also clear presentation on the Inap Salyu case. It is indeed interesting and a refreshing decision, yeah, which successfully shed some guiding light on these rather uncharted waters relating to short-term rentals in Malaysia. Yeah, so next we will have Saravana to speak, our final speaker, to speak on the IRB's special program for voluntary disclosure and other issues relating to property development, including, issues on income recognition, Bumiputera unit release fees, withdrawal of stocks, and also expenses incurred relating to property development. Over to you, Sarah.
Thank you, Ms. Ooi. Let me just get my slides. There we are. Okay. Good afternoon, everyone. And I thought I will start. Reason why we have this topic, because property developers are a favorite to the IRB, and IRB enjoys going after the tax developers and contractors. They think developers are always, a good lot to go and get audit issues. So I thought, since we are covering it, let me cover the common issues that I see developers are facing the last few months. So first position is in the case of P, a very recent case which was settled out of court eventually. For those who are very keen on taking part in voluntary disclosure, I don't know whether you all have had the chance to read the pre-budget statement by the Finance Ministry a few days ago. They're intending to bring in a voluntary disclosure for customs. Please think very carefully before you take part in customs, because if you go make the wrong admission, they'll charge you for criminal offenses. Customs are known for doing that, and I have on record a lot of our clients are being threatened that if you don't compromise or settle the case with the customs, then they will investigate you for criminal matters and all that. So although politically Malaysia may be getting more mature, civil servants, like the customs, do require a bit of still, I guess, some counseling on how much they can use the power and how to use their power. They forget absolute power. That there's no such concept as absolute power. But anyway, someone has to take them to court to show them that, So here, taxpayer was very eager on voluntary disclosure, simply because they were in the middle of a tax investigation by the IRB for whether the lands are all subject to income tax or RPGT. Taxpayer filed RPGT, income tax wanted them to pay income tax. So during the middle of the SVDP, the IRB went and told the client, we will settle your matter for RPGT, if you pay another, $800,000 more. So taxpayer thought not a bad deal, quickly signed up for SVDP. Mind you, the offer came from the IRB, the email correspondences, they sent the form, taxpayer fills up the form, the tax agent signs it, gives it, collect the money. Then, before year end came in, IRB has to change its mind and decided to turn it into an income tax and ask taxpayer to pay 96 million ringgit in income tax. Okay. Question: is voluntary disclosure made under the SVDP binding on the inland revenue? Legal answer: it is not binding at all. Okay. So if you're all now victims of audit, if you all are complaining about there are more audits now, well, SVDP, in my view, it was an exercise for the government of the day at the time to go and collect data about taxpayers. And data about taxpayers who have been recalcitrant and have not paid their taxes. So whenever, tax authorities want to do SVDP and they don't give you a watertight binding position, I think you must be very, very careful. It reminds me, because I got a young child at home, I read him these books, baby books. All this, inevitably, I forgot, Mr. I don't know if you know the name of the story. Red Hood hiding, the lady, the wolf, where the witch will come or the wolf will come and tempt you, by telling you, come to my house, I'll give you all these cookies and these goodies and all that. And the story, all the stories about some witch, but who pretend to be a very nice person, enticing you, and once you fall into the trap, then they show that they're a witch or they're a monster. So I'm not saying tax department is a monster, but many may share that view because your money is taken up by them. But that's what happens. That's a fact. Fact of the matter is they have come to court, putting the submission in writing that the SVDP is not binding on them. It's up to them whether they want to accept, not to accept. And after they accept, they can change their mind. So I hope that gives the participants some idea. Before you sign up into any voluntary scheme in this part of the world, please think very carefully, making U-turns and renegating on their promise, it seems to be very common in this part of the world. So despite the guidelines saying that they will act in good faith, despite the guidelines in para 5.12 says all these conditions are final. Like it or not, this is not the first time Malaysia had voluntary tax disclosure. In the years 2016, 17, 15 to 17, around that period, there was a tax voluntary disclosure when Dr. Sri Najib was the finance minister. And at that time, if you go and do a tax disclosure and you settle your matters, you are given a composite assessment. A composite assessment is binding and the IRB cannot reopen the assessment. However, for SVDP, under the tenure of Mr. Guaning as the finance minister, there was no composite assessment being given. And despite me writing in the papers, urging the government of the day at the time to go and give what they call composite assessment, it was never taken up. And all taxpayers in honeymoon at the time, they thought the government is there, all will be all right. Only now to realize it was never the case. Yeah. So despite you finding all the taxpayer being ticking all the boxes for SVDP, the revenue did not honor it in this case. This is not the first case. There are many more cases out there where revenue has always taken a different view after taking SVDP from the taxpayer. And the response is, it's not binding on us. We can reopen for other issues. So please be very careful when you do SVDP. And in this particular case, we filed multiple actions in court. Eventually, the matter was just resolved not too long ago for a fraction of the total of the taxes demanded by the Inland Revenue Board. So that's the first part. Yeah, SVDP. Even when you go and make the disclosure, please don't go and say, yeah, I never keep my books properly. Saya dengan ini mengaku, mengaku. That's why they ask you to do all the disclosures. Mengaku terkurang bayar cukai, or under-declared your taxes. Please don't make all these declarations. They're all incriminating declarations. They'll come and bite you. Tax department's role is to collect your money. When someone wants to collect your money, they shouldn't talk too much. Just collect the money and move on with their life. But if they want to come and make you make all these unnecessary demands, you got to think very carefully what is the intention in doing so. Yeah. Office park development, recognition of income. Taxpayers sold the building, and the building SPA was signed in 1998. It became unconditional upon obtaining the Foreign Investment Committee approval in 1998 itself. So the issue was whether the taxes are payable in which year. However, because of the 98 crisis, the buyer could not pay the taxes. Therefore, the payment was delayed to the subsequent year, which is the financial year 1999. Tax year is year 2000, current year basis, which was the tax 1999, which will be 2000 preceding year basis. And the taxpayer said the sale is only completed after the payments are received and when vacant possession is delivered. In other words, when risk and reward moves and when the sale is recognized in the books. So the taxpayer said it is taxable in the year 1999. Of course, Inland Revenue Board said no, It is taxable in 1998 when the SPA was signed. So the day the SPA was signed, sale is concluded, please pay your taxes. So we went to court, we argued the case. You'll be wondering why did we argue for 1999? For those who are very familiar, 1999 was a tax waiver year. So in this case, the taxpayer didn't know that it is going to be tax waiver. The delay of the payment was granted before the tax waiver was announced. So that was not an issue here, but IRB said the SPA date is a recognition date. The special commissioners and the High Court ruled differently. They didn't cite the taxpayer nor the Inland Revenue Board. The special commissioners took the view that the sale was concluded on the day when the contract became unconditional. So not the SPA date, but on the day the contract became unconditional. So in this case, the contract became unconditional upon obtaining the FIC approval. So on that basis, the court ruled that income is to be recognized upon sale and the agreement becoming unconditional. So I wanted to highlight this case. That means you don't have to recognize the income based on sale, but when the contract becomes unconditional. All these are in the slides, so I'm not going to trouble you with that because there are many questions I see on the board. Next is Bhumiputra release fee. We are very fortunate. Courts in a number of cases have ruled that it is a deductible expense, but Inland Revenue Board has appealed to the Court of Appeal, is pending at the Court of Appeal. And the issue here is, can developers take a deduction for the levy or the penalty they pay to the state authorities to get the release of the Bhumi units and the Bhumi quota? Common sense will dictate, that this is all very common. Taxpayers got to pay this penalty or this payment or this levy in order to claim a deduction so that they can sell the units to a non-Bhumiputra buyer. The irony is when the units are sold to a non-Bhumi at a higher price, inevitably, right? Revenue taxes the taxpayer, the developer, on the high sale price. But the expense you incur to make the sale possible, not allowed. Why? It is penal in nature, according to the IRB. It's penalty in nature. So really couldn't understand that, because this is penal in nature, because some state governments use the term penalty. Some state governments call it contribution. But the purpose of the payment is not to punish. The purpose of the payment is a levy you pay to get the release of the Bhumi quota. Penalty is only imposed when you sell the unit to a non-Bhumi without prior approval. Then there is a penalty for that. And I don't think taxpayers are deducting that penalty. What the taxpayers are asking, the developers are asking, is to deduct the expenses they incur in order to go and get the state government's approval to sell the units to non-Bhumiputra. And these are all Bhumi units which could be sold. So in order to project sales, they go and get this approval. Common sense, but I guess it is a rare commodity nowadays. The revenue doesn't see it from that angle. And there are cases in India where businessmen, companies overload their lorries in order to sell. More you load, the more you can sell. Of course, overloading is an offense. They have to pay a fine to Road Transport Department. So the companies know it's overloaded. They prepare the fine. When they get stopped by the Indian JPJ, they pay the levy and they move on. They say this tax deductible, and the Indian court says deductible. Because the higher load, the extra load, they earn more money, they pay tax on it. Similarly, in Canada, there is a case where to produce eggs, there was a quota. There's a particular egg producer who produced above his quota because there's a demand in the market. He paid the levy, the penalty imposed on him, and the court says deductible expense because the income he makes from the transaction, you end up paying taxes on it. So you know what I mean? Income tax doesn't care about morality, right and wrong. If the income is taxable, whatever expense you incur for the expense to be for the income to be earned should be allowed as deduction. Unfortunately, these issues still being argued in court. And I understand in certain states, even the low cost contribution, the exemption from low cost contribution are also subjected to tax. Yun Lian is a classic case of movement of stock. Taxpayer built shop lots for sale, but eventually rented out the shop lots. And when he rented out the shop lots, they didn't deem it as a sale. So IRB, during an investigation, decided to bring it to tax because Section 24, subsection 2 was invoked, which says that if you withdraw stock for own use, you got to pay. You got to deem it as a sale. Property developers, I think now would have learned by now that if you buy stock or if you build a stock and you keep it for your own use, you got to pay tax on it. There are no two ways about it. Tax is payable. Yeah, is a deemed sale, although it's life pocket. It is still a right pocket, left pocket. The property is still there, not sold. Please tell your bosses. The Income Tax Act under Section 24(2) deems it as a sale by operation of law. Okay, so I just wanted to highlight that. But the question I want to ask, ladies and gentlemen, is this. Now the market is not so great. Many developers have units, especially commercial units. And what you do in the meantime, you rent it out for free. You come and tell people, come and use it for rent free for 12 months or 2 years. Don't need to pay any rent, because that is one way how to give life or rejuvenate a particular project that is otherwise it looks abandoned, right? So to get a footprint, people do that. People do invite the big tenants to come and use it for free for a period. Does that mean there is withdrawal of stock when it is given rent free, or say for a $1 rent? My view is no, if the property is still available on the market for sale. So you must actively try to get the property to be sold in your tenancy to your whoever you give it to for $1 for free. You make it very clear in the tenancy that the property is available in the market for sale. It can be sold at any time, and it can be sold with the tenancy as well. So if you are able to make it very clear that it is still stock and your auditors are convinced that it is still a stock, it remains as your current asset in your books, I think you got a case to argue it is not withdrawal of stock yet. Yeah. So this is one point to go and ponder. Yeah. And finally, on the position of incurred, I see a lot of developers facing this issue now, especially now, where you accrue your expenses but not paying it out. Market is bad. When market is bad, cash flow is an issue. You don't make payments, but you accrue the expenses. And the case here is involving a developer where they built townhouses, low-cost townhouses, and there were certain title requirements. And to obtain the title, you got to pay what you call survey fee for the certain title to the state government. And because they had cash flow issues, in the books they accrued the expense, because under the law, certificate of fitness or certificate of occupation have been issued for the SATA units. So under the law, but I believe 6 months to go and get the SATA title applied. They prepared everything. They got the plans all drawn up. They knew what's the fee to pay, but because of cash flow, they didn't make the payment to the state government. Yet people are occupying the properties. The payments were paid much later. But what they did was eventually, I don't know whether they paid, because I did the case, they haven't paid. The IRB disallowed the expenses. The IRB said, this is not deductible because you have not paid it out. You got to disburse it. Yeah. So we argued successfully in this case that no, as long as an expense has been incurred, it means you got an obligation to pay. It has been accrued in your books. Once it has been accrued, you can take a tax deduction. There is no basis for the IRB to insist you must have cash payment for this payment. I argued this point in the case of twin insurance as well, where we said, you must be very clear on this. IRB cannot go on cash basis for expenses. Income is recognized on accrual concept. Expenses must also be recognized on accrual concept. So this is what I wish to share with you all today. I see a lot of questions. Perhaps it is timely for now for us to go into questions.
Thank
That
you,
is a
Sarah,
story,
for
Eleanor. Little Red Riding Hood. Yes,
Yeah,
that is
that's
a
right.
book.
yeah, and also Snow White and
Snow
the Seven
White,
Dwarfs.
yeah,
I think,
you know.
yeah. Okay, thank you, Sarah. Interesting topics, certainly, to some of the attendees which you have just shared. Now we have quite a number of questions, so I would like to go straight to some of the questions that we see from the attendees. Okay.
I saw one from my good friend, Sulip.
Yes.
Yeah.
Okay. Yeah. So I will pose the question. Sulip asked, was the FC decision, federal court decision, that regulation 11 subsection 3 ultra-virus and has retrospective effect? That would be addressing to you, Loong Thye.
Yes. Yeah. Hi, Sulip. Nice to see you. Our regular attendees. Well, this is actually the very important question asked, and a lot of people have, in fact, have discussed on this, whether the unmanly federal court decision is a retrospective in a sense that it applies even to those cases before unmanly, or prospective in the sense only for future cases. There is one High Court decision which was mentioned in my talk. That is the Albin Young case. The High Court expressly dealt with this issue and came to the conclusion that it has a retrospective effect. So very unfortunate decision from the developer's point of view, that is they're caught by it. So my personal view is that it's also quite difficult to argue that it has a perspective. Hopefully, with matters going to the federal court, this issue may be, we call, re-argued, and we see what is the federal court of the future will have a look and will have a view on this, whether it's retrospective or prospective.
Okay, thanks. Thanks for your elaboration on that issue and your thoughts. Now we have a question. I think this would be addressed to Gek Im. Does the status of the title make a difference for short-term rental or stay, i.e. commercial title, which are for service apartments, versus residential title for condos and, you know, those kind of strata title property?
Yes, thanks, Ms. Ooi. Oh, yes, definitely. If the use of your land is only allowed for residential use, that means you definitely cannot run a commercial use on it. That means include a short-term rental. So to make sure that you can actually run a short-term rental in that premise, the title has to allow commercial use or stated for service apartment or commercial building.
Okay. Now, another question. Someone put in a question which goes like this: when the MC, Management Corporation, goes to court, who bears the legal costs? Yeah, it says here, presumably is the MC. Does the MC need to get approval from the parcel owners via an EGM?
Oh, under the Strata Management Act, the MC is actually empowered to take action. For example, if you want to enforce the bylaws against those who are breaching your bylaws. So they are actually empowered to take action in court or even in tribunal against those infringing the bylaws. So they actually don't need to get approval from the residents or run an EGM to get approval. And furthermore, the Strata Management Act also allows them to use the money in the maintenance account to pay for all the legal costs and all that. But of course, if you win the case, then you can actually try to claim costs against the other party so that the MC or you don't have to pay from your own funds.
Okay. All right.
Before, I saw one question here, I think meant for me.
Okay.
It says that I have is there a difference in outcome if the developer applied for extension of time before or after the SPA was signed? This is a very important question in the sense that it goes to what we call the consent of the purchaser and the meeting of minds. Now, if the extension of time was made before the SPA was signed, it is argued that both the parties have entered into the sale and purchase agreement with the eyes wide open. So if, for example, the minister approved the extension from 36 months to 48 months, then one can argue that, look, you purchaser, you knew about it. So you signed the agreement. Of course, that is if on the basis that the extension by the minister is held to be lawful in the court of law. But what happened if the extension of time was granted after the SPA was signed? As I mentioned in my talk, regulation, there seems to be some argument that it can be done after SPA is signed. But the related counter argument against that is where the purchaser is arguing that you have deprived me of my right to claim for liquidated accident damages, and you actually granted extension of time after I've signed the SMT. So this case was actually argued in the Armini case at this point. And the court says that, look, it's not fair to the purchaser. The purchaser should be consulted first by the authority. Assuming that case, of course, they were talking about the controller, before they allowed the extension of time, because in that case, the SPA was already signed. I think there's some basis in that, where the whole purpose of the HDA is to protect the purchaser. So after they sign, you unilaterally, in that sense, ask for extension of time. So here, I would think that there is a lot of improvement that need to be made, and to be discussed among all the parties moving forward. That is with the Ministry of Housing, the developer, and of course the Home Buyers Association. How do we overcome a situation where there is a genuine need from the technical point of view, from the construction point of view, or even because of force majeure, the kind of situation where the project cannot be completed within the original 36 months, and there's a need to extend it. So maybe this is something where the various associations can take it up with the government on this.
Yeah, so like, of course, the pandemic causing disruption to the supply chain and all that.
Exactly.
In terms of supply of raw materials and building materials. So in situations like that, where it is not, due to any cause or reasons within the control of the developer, yeah.
Yes,
so in situations like that, I think it would be a valid reason for the extension of time. Yeah.
On that point about the pandemic, COVID-19, the government dealt with it last year, where they have this COVID-19 Act 2020.
Yes.
But for some, they also deal with what they call automatic extension of time, but only for 166 days. I don't see why it is limited to 166 days. But what is really unfortunate is that the COVID-19 Act was not extended to this year. So a lot of developers are also caught by that. Although the project is delayed because COVID-19, but they cannot have this legal remedy.
Right. Okay. Now we have a question for Saravana. Okay, it's a few questions. It's relating to SVDP. Does it amount to an admission of liability or guilt? And if we file a SVDP and did not receive a clearance letter, although IRB has already accepted the SVDP, can they be barred from raising, that means the taxpayers, can taxpayers be barred from, or no, can the IRB be barred from raising other issues, yeah, relating to the subject matter? And can IRB also initiate criminal investigations for matters which are voluntarily raised, yeah, against the taxpayer in the SDVP?
A good question. Number one, if you did admission to liability, depending on how you word it, if you go and say, yes, I never paid my tax for the last 10 years, yeah, you are, of course, admission of liability, it's guilt, what else we call it. So it's better to go and say, that on, on technical reasons, I decided to pay the extra taxes or without admission of liability. But if you remember, IRB wants you to do all this declaration, and you look at declaration, they're very onerous, right? And especially if you're a professional or if you are going to be a director of a company, you don't want to get into all this headache of making incriminating statements for no reason, So as of course, SVDP per se should not amount to admission of liability, but if you are not careful in how you do it, it can be used against you. So you must be careful about it. Yeah, there is a case called Choppy in Singapore, where he was a lawyer and he was under tax investigation, and he signed and paid a compound. And then there was a complaint was lodged against him to the law society that he has misconducted himself as an advocate and solicitor, and the law society disbarred him on that basis. He went to court, he argued his case, I can't remember his counsel, before LPTN, a panel of two or three judges in the Singapore High Court at the time, acquitted him and said, set aside the misconduct finding, saying that there was ample of evidence to show that Choppy was under pressure to sign the what you call the compound at IRB. For 2 years, the tax department was harassing him in Singapore. So he got tired of them, he couldn't take it. He then signed and paid them 80,000, 90,000 Singapore dollars at the time. And there's some history. His partner was convicted of CBT in his own law firm, and the prosecutors thought he was also in it. He was never involved in it, but they went after him. When they couldn't find him for anything, the prosecutors sent the tax department to investigate him. So don't think only Malaysia does that. Singapore also does that. Many parts of the world, they do that. And was investigated, and he couldn't take the harassment. Yeah, and then he signed it. So those who are going through a tax investigation will know how much painful it is when you're asked to record every dollar you spend in the last 5 or 10 years. You got to account for it. Otherwise, it's all deemed as undeclared income. So you must be careful in what you do. You filed SPDP, but no clearance letter, but took your money. Of course, by conduct, you can say they accepted your money, like what happened in my case. But they will still come and say they deny it. And even if they give you clearance letters of no value, legally speaking, they're not bound.
All right.
But I think you can sue them for breach of contract. You can sue them for breach of contract. My advice to taxpayers is, if they become naughty to you, you stop being friendly. You must understand, oh, but I want to keep my relationship. What relationship you have? If you have a relationship, they won't do this to you in the first place. What?
Yeah.
Exactly. What relationship?
Yeah.
Your relationship is meaningless. Because you pay so much of money, then they come and attack you again. Then they say, but I say you teach them a lesson. But cannot how relationship will be damaged. No relationship in the first place, So my advice is to sue the officers involved, and including all the heads of department personally for breach of contract, misrepresentation, maybe fraudulent misrepresentation. But if you can get a good counsel like Rosely, he will build up the case for you. Maybe sue them for $10 million. In Rosely style is to sue someone for 10 million ringgit. And if you're a civil servant, you won't be able to pay 10 million ringgit. So let's make him a bankrupt. So that would be how you should play the game. Those a lot of clients on this call, our style. I've been trained in litigation. Chia, I'm sure you heard of this before. Someone throws a stone at you, you throw a brick at him.
Yes.
That is how Naban taught me litigation, so that they know they don't mess with you, Sometimes you got to do that, yeah? Recently, can the IRB invoke criminal investigation when you do SVDP? Of course they can. That's why we have to be very careful. Do not make admission. You make admission, of course, so easy one. The evidence is mens rea. Mengaku, you're not a housewife, Sunday 6 drop out, cannot read, then you go and sign. Cannot lah. You go and sign knowing what you're signing, you see. So be very careful. That's why I said, do not incriminate yourself when you sign all these things. Yeah. Can we bring an? I think you can. If they do that, they breach. I think you may want to look at a claim in law of contract. I don't see why not, if you can establish the elements of a contractual position, and I think law of contract has evolved. It is between tort law and contract, laws of obligation, right?
Yes.
I think there's a basis to pursue it on that manner. Nobody has done that, but we're always happy to do it for you.
Okay, thank you. Now I have a question here from a T.Y. Wong. I think it would be addressed to Gek Im. What can a developer do to prevent residents or parcel owners from banning short-term rentals?
Of course, it's actually very important from day one in your planning, because if you intend to develop the entire parcel as a commercial unit or service apartment, because number one, you got to make sure your land title, it allows it to be used as commercial use. So that's definitely the basis of it. Because number two, of course, when you apply for your building approval plan, make sure that it's submitted and approved as service apartment or Soho or so, wherever they intend for the whole parcel to be. So that's definitely step number one. Well, step two is, of course, when they sign your SMP, in your deed of mutual covenant, you have to make sure that you actually include a clause where to say that all parties will sign and agree for all the parcels in that development land to be run or to be used for resident, for commercial use, for short-term use. So everyone has actually signed the DMC and agree with the terms and condition of it. So we actually have done cases where we help to structure a mixed development as well, whereby we actually crafted in our deed of mutual covenant, whereby we have the rules, the bylaws that controls for the residential use, and another set where it's for commercial use. So if you have done that, crafted all that in your agreement from day one, so the transition period when you hand over in your first AGM, you basically just have to let all the residents adopt the rules that was drafted in your DMC, and then it will be passed as a bylaws or the house rules of the parcels, the building. Then then there are lesser risk of it being allowing the residents to say, no, we don't agree for it now to be used as commercial use or short-term use.
Right. So basically you have to, right from the beginning, when you buy, with your eyes open as to what kind of use it can be.
Yes,
the
correct.
parcel, can be used for, as opposed to, many of these are most of them are residential. When you buy it, it was residential, and there's no such provision in the DMC or the house rules, which expressly regulate or talk about short-term rentals. And that's when you get into trouble, because I do own a condo, and as a condo owner, I certainly do not want other parcel owners to be using all the common property and the facilities and making money and using it for commercial purpose short-term rentals. And I am subsidizing, the cost of maintaining those common property. So certainly I will vote to ban that kind of short-term rental. As with most residential owners, I would think. And that's where the
correct. So that's why the preliminary work is very important for you to set the background so that you won't have a risk of the residents then saying that, oh no, we don't agree to it.
Correct. And also another point, if it's a residential use and the title as stated on the the strata title, and the use of the land is for residential or building, then certainly when it comes to insurance, for the building, that is the purpose and for which it is to be used. And to use it for commercial and increasing the risk of damage and loss, I think it is also very something to take note, for the MC, because any fire or any damage may not be covered under the insurance because it's not used for the purpose that is intended to be used. So I think that's another important point to note as well.
Agree.
Okay. Yes, Sarah.
They should build a condo just for BNB. Just a condo just for that purpose.
No, there is. In fact, on the point, actually, this is where the law should develop with the modernization, in the sense that there are a lot of mixed development concept being introduced by developer. Rightly so, because we talk about commercial, residential all into one development. So the law should allow this, and but game says correct that from day one, if the developer can structure the SMP and they did a mutual covenant to cater for this kind of future scenarios, that would be very good. But Bee Hong, can I just want to add in one point about what Sarah said about suing the tax authorities or officers,
Sure,
Actually,
go ahead.
what came across my mind is the Lee case. You see, what to me is also a case of misrepresentation by the government that the controller has the power to grant an extension of time, and the developer dutifully and respectfully apply for it and got the extension. Then, behold, the federal court said that then the controller have no such power. But who is at fault? It's certainly not the developer. And in fact, if I may, I did some research. What I found was the regulation 11.3, which allows the controller to make and modify, was already in the original Act of Parliament in 1966. So for a good 40 years, everybody has in that kind of impression that the controller has such a power. And suddenly Lee case came. It's very unfair to the industrial players, especially developer. But then the federal court has the reason. So what I'm looking at is actually really a proper discussion between the Housing Developer Association, the Home Buyers Association, and the government to resolve this. Because it's true that the purchaser need to be protected against some unscrupulous developer, and that's why HDA comes into play. But if I may add, there must be a balance between the interest of the purchaser and the interest of the developer. This Lee case has really caused, to me, like my opinion, truly a disadvantaged position where the developer had to pay a huge LAD for no fault of their own. So the government should step in, if I may suggest, to make an amendment and have it retrospective. And so that this is the truly intention of the government to allow the controller or the minister to grant the extension of time for proper reason, of course, not for any. So here I feel that the party should talk about it and have a retrospective act to be passed in Parliament. Okay, so thank you for that.
All right, thanks. So, yep. I think we have one last question.
One last
yeah?
question, okay.
One last question. Okay, that's for you, Sarah.
Yes.
Is IRB appealing against the decision that the release fee payable to release the Bumiputra lot is deductible?
Yeah, they have appealed. Is pending before the Court of Appeal.
Right. Okay.
We heard probably we heard this year, end of this year or next year.
Right. Okay, I think it looks like we have time just up to now to cover most of the questions that we have received today. So thank you very much, everyone. And after today's webinar, you will receive a survey regarding our webinar today. And we would like to request that you complete that and provide your feedback. And further, if you are interested in receiving a copy of the PowerPoint presentation slides, kindly reach out to us at event@rdslawpartners.com. Okay, so on behalf of RDS and all our presenters, thank you again for joining us today and have a good evening. Take care, everyone.
And don't forget our public law lectures tomorrow with Dr. Isha Munin Yunus and Dr. Gopal Sira.
Yes, so please look out for that. This is an event taking place tomorrow. Okay, it's our public law series. So hope to see you all again tomorrow. Take care, everyone, and have a good evening.
Yeah.
Bye-bye.
Thank you.
Thank you.
Bye.
Bye.